the debate about human rights is often more heated when the word Europe is brought into it. Should Europe and its institutions like the European Convention on Human Rights, the European Social Charter, the Council of Europe Convention on Action Against Trafficking on Human Beings, and also the European Union itself have any role in protecting our human rights? Is it not better to be the concern of the nation state rather than Europe and its institutions? Well, in this webinar, we're going to look at the role that Europe plays and its importance in human rights. And we're really pleased that Audrey's come on to do this with us. So I'm going to hand you over to her right now. So Audrey, over to you. And thanks for doing this with us.
You're welcome, Francis. Thank you. And hello to everybody. The first thing I'd like to show you is actually a short video from the organization Rights Info. So I think Francis is going to play that in a moment. It's a great organization that I think has lots of lovely infographics that I will also use during my presentation and put together this short animation. It's really simple explainers on human rights. And especially if any of you have children, I would definitely recommend children, teenagers. I mean, it's good for everybody really, to just understand the topic in a very short kind of span of time. So we'll just start off with that video.
Human rights. What are human rights? Well, human rights are the values which keep society fair, just and equal. They protect children, the elderly, people in care, victims of domestic violence, people with mental health problems, religious groups, teachers, soldiers, and yes, prisoners. They protect all of us. They protect you. Our human rights are protected by law. That means we can do something if our rights are attacked. But not everyone loves human rights. Some want to water them down, even scrap them. Our rights are under threat, so it's time to get educated. Societies used to be controlled by all-powerful rulers who could be horribly unjust. Kings only gave rights to people they liked. Over thousands of years, people fought for equality, and with every hard-won right came new laws that improved how we lived. But in the 20th century, brutal dictators came to power. They ruled by fear, like the kings of the past. Those hard-won rights, they were dismantled on an unimaginable scale. After World War II, the democracies got together and said, never again. They created a simple document setting out the basic rights we all need to live a dignified life. The European Convention puts rights, not rulers, at the heart of our society. Like the right to life, to liberty, to free speech. Then, in 1998, Parliament passed the Human Rights Act, which made our human rights part of UK law. This means public bodies like hospitals and schools must respect our rights, and if they don't, we can go to our local court to enforce them. Now, because of human rights, patients in hospitals must be treated with compassion. Journalists cannot be forced to reveal their sources. Soldiers must be given proper equipment. Gay people have to be treated equally, and the police cannot keep our DNA forever if we're innocent. We have to be treated fairly, at work, at home, in school, anywhere, everywhere. Our human rights are hard-won. They're part of our British heritage. We are proud of them. If we lose them, vulnerable people will pay the biggest price. Know your rights. Celebrate them. Protect them. Share this video if you think human rights matter. Go on. Share it.
Great. So again, that was a video from Rights Info, and it's a website that basically creates different infographics and videos for people to share about human rights, and it's accessible to everybody. So as Francis mentioned, and I think it says on the front, my name is Audrey. I am a legal project manager at the AIR Center. The AIR Center is a European human rights law charity, and what we basically do is use the power of European law to protect human rights. We provide free legal advice where we see there are larger problems impacting groups of individuals. We also undertake strategic litigation. We train lawyers and also undertake policy, including on things like providing submissions to the Modern Slavery Act when it was in bill form. Our projects span various thematic areas from domestic violence, discrimination against Roma. I personally work on deportation, and I'll mention a little bit about that near the end, but generally about standing up for fundamental rights. So today, I'm here to talk to you about Europe and human rights. I only have about 15 minutes to talk, And I realize it's a bit of a diverse audience, so I'm going to keep it quite broad and general and give you a general overview of the main two legal frameworks in Europe, the European Convention on Human Rights and the European Union Charter on European Charter of Rights. And then kind of go into a little bit more on the position in the UK. As I'm sure all of you know, human rights is quite a hot topic at the moment, and it's often conflated with a lot of different issues. So I'll look a bit about that and how the tabloids, politicians, and the general public view human rights. And then just go into a few case examples, drawing on some of the cases the AIR Center has taken to the European Court of Human Rights. And just apologies for the beginning. I am undergoing quite severe allergies, so if I sneeze in between, apologies. So we'll just start with, and not to give you too much of a history lesson, but just about the Universal Declaration of Human Rights. Now this came into force in, was signed in 1948, and it came about because of the atrocities that happened after the Second World War. It was a real milestone in the history of human rights. Because it brought together drafters from different legal and cultural backgrounds from all across the world to really put together a common standard of achievement for all people and nations. And it came to force on the 10th of December, 1948, and this is why we celebrate International Human Rights Day every year on the 10th of December. I just wanted to draw your attention. I mean, the entire document is incredibly important and the principles enshrined there are fundamental, but just the first two articles, because I'll refer to these concepts again throughout the talk, is that Article 1 starts off with all human beings are born free and equal in dignity and rights. And then Article 2, again, this talks about that everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind. And I think that this idea of human rights being universal and fundamental is a fundamental concept because I think we all accept the idea that human rights are important to protect, vulnerable children or people in vulnerable circumstances. But I think accepting the notion that human rights are for everybody. So when they protect us, they can also protect certain people that we may not find, aren't as likable. Terrorists, prisoners, criminals, but this is what human rights is about. It's not only for select groups of people, it's for everyone. Now, if we could move on to the next slide. Again, this is another infographic from the Rights Info Project, but it's about the European Convention on Human Rights. And I'm going to spend a little bit more time on the convention, which was drafted by the newly formed Council of Europe in 1950 and then came into force in 1953. And it was the first step that the Council of Europe took to implementing the Declaration on Human Rights in writing. And it's basically for the protection of human rights and fundamental freedoms. And its aim was to achieve greater international unity and recognize the equal rights of all men and women across Europe. Now, I also want to look at the British contribution to the European Convention on Human Rights, because I'm sure, as often you hear, it seems that there's a divide, at least in some media, between Europe's human rights and Britain. But actually, as you'll see, the principles enshrined in the European Convention on Human Rights can be traced back to the Magna Carta and to the Bill of Rights in 1689 and habeas corpus. It was a British politician, lawyer, and judge, Sir David Maxwell Fyfe, who actually oversaw the drafting process. The first president of the European Court of Human Rights was Lord McNair, another British person. And the UK was the first country to ratify the European Convention on Human Rights. Winston Churchill specifically claimed that the European Convention on Human Rights was a movement towards European unity. And the purpose of the ECHR was that it was set up to ensure that leaders could not be all-powerful, that it was going to protect people against the excesses of the state. Now, if we could just move on to the next slide. This was my attempt at making an infographic, which, as you can see, was a pretty pathetic attempt. But basically, I wanted to just put down the key features that the European Convention on Human Rights The court that's responsible for interpreting the European Convention is the European Court of Human Rights. That's based in Strasbourg, which is where it was signed. And it's the Council of Europe that oversees this. Now, the Council of Europe was set up, the European Convention on Human Rights is responsible for monitoring the human rights for over 800 million people in Europe. And it takes care of the 47 Council of Europe contracting states that have ratified the convention. It is what is called, and it's been called in recent days, a living instrument. So that means it dealt with the rights, but it's also adaptable to new issues. So it also tackles today things like cybercrime, human trafficking, things that were not necessarily conceived of when it was first developed. Now, the key issue is that the judgments from the European Court of Human Rights are binding on the member states concerned. Now, what happens in the UK is that we adopted the Human Rights Act in 1998. And what the Human Rights Act basically does, I'll look at this in a little bit more detail when I look at the domestic concept, is basically allow individuals to be able to access their convention rights in domestic courts. Because as you can imagine, in order to get to the European Court of Human Rights, it's quite expensive and it's quite lengthy. And to have those rights upheld, in your domestic courts, the Human Rights Act was brought into force. Now, if we can just move on to the next slide. The other key legal framework within Europe that I wanted to look at today was the Charter of Fundamental Rights. Now, this is the European Union's Charter of Fundamental Rights. And what that means is that the court that's responsible for interpreting it is the Court of Justice of the European Union. It basically brings together in a single document the fundamental rights that are protected in the European Union, separate from the Council of Europe. It was first set out as a declaration in 2000, but then it was given equal footing to treaties by the Lisbon Treaty and adopted in December 2009. It basically brings together all the rights that are found in the case law of the Court of Justice of the European Union, the rights and freedoms that are enshrined in the European Convention on Human Rights itself, and other rights and principles resulting from the common constitutional traditions of other EU countries and other international instruments. It also brings forth what they call third generation rights, which are things like data protection and bioethics. Now, what's key about the Charter, and I'm going to spend a little bit of time on this, is just that it's, again, it's interpreted by the Court of Justice of the European Union and drafted by the European Union. It can also be seen as kind of an overarching framework for human rights because it does go further than just the European Convention on Human Rights. The European Convention on Human Rights focuses more on civil and political rights, whereas the Charter actually goes further and looks at economic and social rights as well. It also only applies to matters concerning EU law. So it can be raised in courts in the United Kingdom, but only when the UK is implementing EU law. Unlike the European Court of Human Rights, there is no individual petition to the Court of Justice of the European Union, meaning that an individual can't just bring a case. It's usually cases that are brought there are either references from national courts or cases brought by EU institutions or member states. Now, the key aspect, yes, if we can move forward, just looking at what is happening in the UK, I'm sure this doesn't come as a shock to anybody, but this is what we see currently from certain tabloid newspapers, this idea that it's about, a separation between Europe's human rights as distinct from British human rights, or actually almost even worse than that, that this sense of European human rights threatens the British justice system. Now, of course, I've already mentioned this is completely in contrary to actually the history of where the European Convention on Human Rights comes from, which is very much from British drafters, principles that were already enshrined in a long-standing common law. But this is the way that it's spoken about today. And the other key issue is that it highlights this fact, or it purports to highlight, that the only people that are helped by human rights are criminals and terrorists, and not like in the Sun article, I'm not even sure who these people are, just random people on the street. Unlike your human rights, it's only protecting individuals who like terrorists. And this is actually really disconcerting, especially when you take it in together with the framework of where the European Convention on Human Rights came from. And then you hear statements that Theresa May made just yesterday or the day before, speaking about this idea of the EU referendum. Again, conflating these two issues, but specifically talking about the ECHR, she said that the ECHR can bind the hands of Parliament and adds nothing to our prosperity, makes us less secure by preventing the deportation of dangerous foreign nationals, and does nothing to change the attitudes of governments like Russia when it comes to human rights. And again, it is really disconcerting to hear statements like that from politicians, knowing that, but at least in my opinion, not incredibly surprising when, again, the purpose of the Convention on Human Rights was to protect us against excesses of the state. So knowing that politicians aren't always in favor of human rights doesn't necessarily always come as a surprise. But how is the UK actually doing? If we can move on to the next slide. Is the UK okay? How often does the court actually rule against the UK? Again, this is an infographic from Rights Info. And if you look at the 22,000 applications, 22,000 plus applications taken against the UK, only 513 came to judgment because often applications are lodged, but for example, an individual may not have exhausted domestic remedies. And in order to bring a case to the European Court of Human Rights, you have to have gone through your domestic procedures first. But in all those judgments, only 301, these statistics were as accurate as 2015, judgments found a violation, at least one violation against the UK. So that's 1% of the judgments. That means the UK is winning about 99% of the time. This is very much in contrast to statistics that have been told in certain tabloid newspapers. And who are the people that are being protected? If we look at the next slide, again, you'll see, again, contrary to what you see, yes, of course, individuals who are terrorists, criminals, and prisoners can also use the European Convention on Human Rights. Again, going back to what I mentioned when we looked at the Universal Declaration on Human Rights, that is the nature of human rights. It is for everybody. That means it's for us and for individuals who we may deem deserve those protections, but it is also for people that aren't unnecessarily sympathetic. But the majority of judgments against the UK were for other people. They weren't for prisoners and criminals and terrorists, unlike what you often hear. Now, what does the Human Rights Act actually do? Now, again, I mentioned that the UK signed up to the European Convention on Human Rights, and this meant that individuals could take, sorry, if we could just pause the presentation for a moment. The Human Rights Act, what it actually does, it means that instead of having to go through the very lengthy and expensive procedures to bring your human rights claims at the European Court of Human Rights, in the UK, individuals can actually access those rights in domestic courts. In 1966, when individual petition came around, you had to only use those rights in the European Court of Human Rights. In 2000, when the Human Rights Act was incorporated, it brought the European Convention on Human Rights into domestic law. Now, these were already rights that we had agreed to. It wasn't bringing in anything new. It was rights that we'd agreed to that were enshrined in the European Convention on Human Rights, rights that British politicians and lawyers drafted. We just made it easier for individuals who had those rights infringed to be able to use those rights in domestic courts. Again, it also doesn't mean that those individuals are always going to win. It simply means that they can access those rights in domestic courts, and that English judges and English courts could rule on those rights. Now, specific sections of the Human Rights Act, the key one is basically Section 4. Now, this just means that if there's a ruling in Strasbourg that and the UK courts are trying to interpret one of the convention rights, And the interpretation of that convention right, interpretation of legislation in the UK is not compatible. Legislation or policies or practices in the UK is incompatible with how they see the interpretation of the European Court of Human Rights, of the European Convention rights. Then the UK British judges can make a declaration of incompatibility. Now, again, this doesn't change the law. This is not the European Court legislating in the UK. It simply means that then it's up to Parliament to determine whether or not they're going to change the law. So oftentimes, in almost all the cases prior to the prisoner voting case, Parliament did change it, because there is the point of signing up to the convention was to bring Europe together under fundamental rights protections. But as you can see with the Hirst case, which is the prisoner voting case, Parliament still hasn't legislated. And so what are the rights we're actually talking about? And this refers to the slide that we're looking at right now. The rights that are enshrined under the, sorry, it's the slide previously. The rights that we are protecting is rights like, protection against torture, protection against arbitrary deprivation of our liberty, protection against forced labor and servitude, making sure that we have a right to a fair trial and remedies when we have cases brought against us. The right to the freedom of expression, being able to say what you want to say, but not all of these rights are absolute rights. So freedom, the protection against forced labor and servitude is an absolute right, and it cannot be curtailed. But things like your right to freedom of expression is a qualified right, and so it's balanced against other rights. And if you look at the cases in which the rights that are most violated, again, we hear a lot about these issues about Article 8 rights and family and privacy rights being used, to stop the deportation of individuals. But actually what we see is, first in this first slide, this is throughout Europe, the right that is mostly infringed is the right to a fair trial, a fundamental right to make sure that should a criminal charge be brought against you, that you have the right to be properly, to have all access to a proper fair trial and remedies and access to justice, so that your trial is properly heard, and that is a fundamental right. If we look at the next slide, we can see how often, sorry, the slide before, is actually looking at, again, the rights, the cases that the UK loses. And again, most of the time it is the fair trial rights. But how's the UK doing generally? Again, we hear often, oh, Europe's, infringing on our sovereignty. But actually, again, as with most countries that signed up to the convention early on, the UK is doing quite well. And we win one of the highest proportions of judgments. We're like third in tie with Netherlands. So we're not doing as badly, which is great. And so it seems like the fears against human rights are not necessarily factually based, but instead are very much based in a tabloid frenzy. And there are further issues. I'm not a constitutional lawyer, so I don't want to get into this in any extent, but there are difficulties that the government will face if they try to implement a British Bill of Rights. When we're looking, sorry, excuse me, at devolved nations, for example, and what Scotland and Wales would do in terms of unraveling the constitutional entanglement. And it's unlikely that they would agree to just pulling out of the European Convention on Human Rights altogether. Now, when we think about the British Bill of Rights, is it as bad as all that? If we look at the next slide. Now, it might sound like a good thing. So if in the original proposals that came out, some of the statements were, it started off basically as Britain has a long history of protecting human rights at home and standing up for those values abroad. All sounds okay. From the Magna Carta in 1215 to the Bill of Rights and the Claim of Right in 1689. And it talks about the convention being an entirely sensible statement of the principles which should underpin any modern democratic nation. But I think that anybody who has been listening to the news recently, or if you even read the original proposals, it talks about this idea of mission creep. It also says that the role of the UK courts are undermined when deciding human rights issues. It says that the European Court of Human Rights undermines the sovereignty of Parliament. And this idea of breaking the formal link between the British courts and the European Court of Human Rights. And it says specifically that it wants to limit the use of human rights laws only to the most serious cases. There is nothing, obviously these are just initial proposals, we haven't yet to see the actual proposals, what it would mean to limit what is only the most serious cases. It also doesn't expand on this idea of below a certain threshold, human rights will no longer be applicable. What is that threshold? And again, if it's it is a doctrine that came about in order to make sure that we are protected against the excesses of the state saying that we want to break that link, or that we should curtail who human rights are, which are universal, who they should apply to, it's definitely putting the UK's good reputation as a defender of human rights, again, I've shown you how well the UK is doing, at risk. Already we've seen when the first idea of these proposals came out 2 years ago, we saw that Putin said that if Cameron plans to leave the ECHR, why should we have to listen to any of it? Even Kenyatta mentioned that he wanted to fight the charges in The Hague, because why should he have to listen to external powers and international powers limiting his sovereignty if the UK doesn't want to do it themselves? The UK plays a very significant role in upholding fundamental human rights, and it is severely threatened if we try to break this link. In addition to that, the European Convention on Human Rights and the European system, that regional system for the protection of human rights, is stronger than any other system. As many of you will also know, the United Nations system itself doesn't have the kind of enforcement mechanisms. So that means that if principles are violated under the UDHR, there isn't necessarily a court that individuals can go to have those rights protected. Whereas the European Court of Human Rights gives people that enforceability, so that human rights aren't just there as something we talk about. It's something that actually can be enforced to protect you. Now, before we end, I just wanted to look at a couple of cases, so we can pause the slideshow right there, because I think that's probably the best way to talk about so if we just pause the slideshow just quickly, I just wanted to mention a couple of cases that the Air Center was involved in, because I think that's the best way to understand exactly how the European Convention on Human Rights and then the Human Rights Act itself has been able to support and protect individuals. So the first case I wanted to look at was Osman. Now, this is before the Human Rights Act came into force. So this is Osman against the UK. And this case, which the Air Center was involved in, concerned a young boy who, when he was in school, he was basically stalked by his teacher. And, his parents complained, the principal complained, they asked the police to do something about it. Their tires had been slashed, they noticed him outside the house, and they repeatedly reported this to the police, and nothing was done. Now, what ended up happening, sadly, was that the teacher eventually came to Osman's house, shot and killed his father. He also went to the principal's house and shot and killed his son, and nothing was done. And now when Osman and his mother brought the case, now this is a case every young lawyer learns about, when the case was brought to the domestic courts, because obviously the police are a public authority, the question was, okay, had they breached their rights, Osman's rights? And it was found that there was no breach, because there was no positive obligation on the police. And that's what the domestic courts found. So at much expense and time, Osman and his mother took the case to the European Court of Human Rights, where it was decided that there is a positive obligation on the police, a duty to investigate. and that it is the police's responsibility to investigate when individuals complain about a crime or being stalked. And I think that that's a really important principle that we have, that simply because, and granted and acceptedly, the police obviously have a huge remit and lots of things to take care of. But if somebody is reporting a crime and reporting that they are being unfairly dealt with, the police do have a duty to take care of that. One final thing.
Can we, hi, I just got to can we go to the second case study later, because time is really moving on and we've got quite a lot of questions coming up, and I just want an opportunity for you to answer those questions. But before we do, what people have said about us at GlobalNet is we should try and do calls for actions when we do things as much as we can. So in a way, this is going to be our first call for action, in the sense that if you're concerned about some of the things that Audrey said and you're interested in being involved, then you have a crowdfunding site, don't you, Audrey? Do you want to tell us about that? And while you're doing it, I'll put the link up on the right of the screen, so if anybody wants to link to that, they can.
Okay, great. Yes. So just quickly, we are doing a crowd justice appeal because from the research that I've been undertaking over the last year and a half, I've come to notice that actually a disproportionate amount of people are being deported under the new immigration regime, even though, you know, specifically targeted specific nationalities, Romanian and Polish individuals. Also under this operation that we're challenging, Operation Nexus, we believe that the right to a fair trial is not properly being upheld, and we believe that the policy itself is unlawful in the way that it's targeting specific individuals and also homeless individuals, and the way that it's dealt with in the courts, because it's in the immigration tribunals, is not fair on individual people. So the AIR Center is trying to bring this case. Unfortunately, because of changes to the criminal courts through the Criminal Courts and Justice Act, it means that even a charity as small as the AIR Center, we could face cost sanctions if we bring a case. So we're trying to do some funding on crowd justice. Luckily and happily, today we actually reached our first amount, but we definitely have much more legal costs that we're going to come into. So we have a stretch amount, and we're just fundraising to stop these unlawful deportations.
Okay, thanks very much. So you can see on the right the link if you're interested in signing up to that, and that would be great if you did that. Anyhow, let's go to some of the questions that are coming up now. There is quite a little discussion going on, I know, in the discussion panel, and Fabrice was the first person to raise a point. He said fundamental rights has 27 countries, although the Council of Europe has 47, and Russia is a member of the Council of Europe, are they not? And that's a sort of a wider organization.
Yes, exactly. It's a much wider organization, and what it means is two things. So when the UK properly upholds the European Convention rights, it is acting as an example to Russia to say that you yourself need to, you know, implement the judgments of the court. But when the UK politicians say that they no longer care about the European Convention on Human Rights, it means countries that are much worse in terms of their protections of human rights can simply just say, well, if the UK doesn't want to do it, why should we do it? And that means across Europe and further than Europe, this is going to be a significant impact on the protection of human rights.
And Richard asks, where do people go to when the British law supports the state, for example, NHS and local councils, and you can't get redress against the British government? Is there a human rights issue there that Europe can deal with?
Sorry, I didn't quite understand that.
When the British government is supportive of institutions rather than individuals, for example, local councils, yes, the NHS, and an individual wants redress, yeah, and they can't get it through the British government, is this where they can go to a European institution?
Yeah, so it's all public authorities are required to make sure that they are upholding the European Convention on Human Rights when they enact their duties. So it's not simply just the Home Office of the very large. So that's why the police are involved. Any public authorities have to properly implement the European Convention on Human Rights. And then if your rights are infringed, yes, you can bring a claim to say that these rights were infringed. In your
okay.
Yeah.
Okay, and Michelle asked the question, how do local UK court closures affect the individual's access to the European Court?
So this is a bigger question, really, and it's about access to justice generally. Lots of court closures, lots of curtailing of legal aid. This is a much bigger issue right now. It means that it's going to be difficult for individuals to bring their cases. Again, this is why we're doing our Crowd Justice. The AIR Center is a charity. We have to take those cases because those individuals couldn't afford lawyers. Yeah, this is a big problem, and it's combined and growing with all the different pieces. It means that it's going to be more difficult even domestically. But again, because of the Human Rights Act, it will be still easier to bring a case domestically than it would be to go all the way to the European Court of Human Rights.
Okay, and Callie says she strongly disagrees with what she calls the cautious system of the UK court system, of the UK rather, and she believes that only the court should decide someone is guilty or innocent. And she argues that the police often close cases rather fast than properly investigating. And that creates areas that are contentious, like racism and so on. I mean, when the courts aren't deciding and the law enforcement bodies are by their discretion, is there any access again or redress in the European courts?
Yes, and I think she's mentioning the caution system, right? So when police give cautions, yes, again, there's definitely issues in terms of racial profiling and what's happening. And Open Society does a lot of work on that. But definitely, again, the police being a public body, what we're doing right now, these kind of cases can be brought. I understand, I think I'm just reading the comment on the side, this idea about a caution, you're given it. And what we often find is, especially when an individual is a non-British national, and they have, say, numerous cautions, which doesn't mean that they've actually, like Callie's mentioned, you haven't gone to a court, you haven't been tried, you haven't been found guilty of something, you've been given a caution. But in an immigration tribunal, that information can be used against you to say that you're actually not conducive to the public good and that maybe you should be removed from the country. And that is problematic, especially, so when we talk about racism, there's definitely the issue of racism against British people who are of minority groups. But there's this, especially with the new immigration regime, a much bigger issue of non-British nationals and how the immigration tribunals, which don't have the same level of, they don't have the same threshold of rules of evidence as the criminal courts, and how these things like cautions can be used in those tribunals to basically get rid of people out of the country.
Okay, and Lisa Kay has actually quoted from the Human Rights Act to sort of clarify some of that as well. And Rajan asked the basic question, is the general principle that human rights should be managed by each country individually and only move to a higher level if that hasn't satisfactorily been settled? In other words, there's a principle of subsidiarity in law.
Yeah, but it goes both ways, right? So I definitely agree. That's why, again, having the Human Rights Act here makes sense, so that the country itself has to deal with those issues. But it's also this idea of bringing together Europe, right? That was the problem. That, after the Second World War, after the World Wars, there was this division. And it was this idea that if we come together, even though we have different legal systems, we have different cultural backgrounds, there are certain rights that are fundamental to all people. Doesn't matter where you come from. And those rights enshrined in an external, not an external document, but a global document and then a regional document should then be impacted and implemented in your country. And then it is for this country to then implement that properly. But what you want is, should that not happen, there to be an external court to make sure that those rights are upheld.
And Rajan asks another question as well. He says, who can actually change the contents of the Human Rights Act? Is that a legal thing, or is there heavy political influence when that happens?
Yeah, those are it's Parliament who has responsibility for doing that, right? So the courts can't do it. As I mentioned, Section 4, it's just, what it says is it's a declaration of incompatibility. And maybe I could clarify slightly right now, because I talked about the European Union, but I didn't really talk about it in a more significant basis. But when it's EU law, that has direct effect in the UK. And that means that actually, if there's a piece of legislation that is incompatible with EU law, judges can strike down that piece of legislation. So, for example, the Air Center took a case against the State Immunity Act because certain individuals weren't able to uphold their fair trial rights and were also subject basically to domestic servitude. And it was in complete contrary to Article 6, fair trial rights, and Article 4. And what happened was the courts were able to rely on EU law to say, actually, the State Immunity Act is incompatible, and that means we're going to disapply it in this case. Whereas, so that's European Union law. But when we're talking about the European Convention on Human Rights and the Human Rights Act, all the Human Rights Act allows the courts to do is say, this piece of legislation is not compatible with the way the European Convention on Human Rights and the interpretation from the court, and that's all they can do. And then it's up to Parliament to legislate and change that. And like I said, most of the time that's happened. But say, for example, in the prisoner voting case, that has yet to happen.
And Rajan asked another question as well. He says, in the case of the Osman case, could the police have claimed that government cutbacks would not have allowed them to allocate resources for that action?
I mean, those are the general arguments that you get, right? And you can understand that there is a balance that has to be struck. And this is the other thing that's often ignored when we talk about either EU law or even the European Convention on Human Rights law. It's not that everything is a blanket protection. Everything is balanced against what the state can and cannot do. There's a margin of appreciation for the state to be able to interpret the laws. But in this case, they completely disregarded the complaints that were coming, and it led to the death and severe injuries of individuals after numerous complaints, and they didn't uphold their duty. And so now there is a positive duty on the police. And yes, of course, they can say in certain cases, and that will be the argument against it, that we don't have the resources. But that's how it's decided in the courts. Did they do enough to satisfy their positive duty? And I think that's fair.
Fabrice has actually put a video up that he was involved in an interview he did last year. So if people want to link to that, they can. And Fabrice, it would be good if you went to that Word Lecture project site and put that video up on it. If you could do that, that would add it to the database, and then people would have it there in perpetuity, which would be great. Dr. Matai is saying that public services like the NHS, for example, should be required to conform to human rights and must be tied to the courts of law in cases of violation. Are they not already, Audrey, or is that a problem area?
Sorry, 1 second.
Sorry, I know you're struggling through a code. It must be difficult. I've been taking your human rights away. We've made you do this when you've got a code. It's awful. We'll be in the European courts. But yeah, I mean, Dr. Matai is saying that large public services should have to conform to human rights legislation, and they must be tied to the courts of law. He has a feeling, I guess, in his question that they're not, and that individuals can't get redress when injustice is made against them. Now, is that something that they go through the English courts first, and then the European court, and what is the process?
Well, so first, you always have to go through the English courts. So to be able to take any case to the European Court of Human Rights, you have to exhaust your domestic remedies. So that's just the first point. So you always have to go through your individual courts, which again is one of the reasons why the numbers in the infographic I showed you are there's such a discrepancy between 22,000 cases. I will look into a little bit more about the NHS and how that's being dealt with. And I can maybe post some things on the forum after.
Okay.
I feel
Well,
like it might be a bit more of a complicated discussion at the moment.
okay, sure. We're getting close to the end, and there are a few other points, so not many coming up, and some may come up. So let me ask you one before we go to the final video. And we do have a final video, everyone, so hold on for that. It's quite a good one. I mean, when we're talking about human rights, Audrey, we're talking about individual human rights. Is there anything in European law or in the UN law, in fact, UN view of human rights that applies to communities where communities are protected? I mean, you come from Canada, and First Nation rights are very, very important there. It's a controversial issue in Canada. And in this country, we have communities who also feel that they're suffering discrimination of some kind. So does human rights involve communities as well as individuals?
Yeah, when we say individual rights, what we're talking about is, yes, so if you specifically have been had your rights infringed, there are protections against that. But yes, communities themselves, and that's where sometimes the Charter rights actually goes a bit further when it looks at discrimination against certain communities. But there are discrimination provisions, obviously, in the European Convention on Human Rights as well. And as I mentioned, the case that actually the Air Center is looking to bring, some of the issues that we are highlighting is some of the discrimination that is faced by certain communities, and that's a lot of the work that the Air Center does. So discrimination against Roma communities, also individuals who are homeless or just find themselves either rough sleeping, or they may not be rough sleeping, but they just don't have a fixed address, and that kind of discrimination that they face. Yeah, so definitely groups of people are able to use the convention.
Okay, and finally, before we come to the video, okay, no, Michelle's asked a question, so let me take her question rather than mine. She says, do you work with other equivalent European NGOs, charities in other European countries?
Yes, the Air Center has been around for about 24 years now, and we work very closely across Europe with other organizations. Most of our projects are, so we run a trafficking project that works with partners in Ireland, in Croatia, and Bulgaria. We find, especially if you're going to be specialists in European human rights law, you want to be able to make sure that you're gathering information from different countries and using that. And then we work with organizations. We do a lot on the refugee crisis as well, and do a lot on the Dublin regulations. So we work quite closely with other organizations who campaign or work in that area. So yes, quite a few both European-wide organizations and then larger organizations in the UK itself.
Okay, all right. Well, thanks, Audrey. That was quite a struggle for you to get through with the code, and you did that really remarkably well. So thank you for doing that. So we sort of come to the end of this, but before we do, we're going to play a video, but I'm also going to remind you, and I'll put it up again, that if you want to find out about all our events in GlobalNet 21, then joining our meetup site is by far the best way to do it. That will give you a list of all our coming events and our past events. And if you have any ideas about webinars you would like to see or do or be involved in, please contact me and then we can talk about it. But click onto the meetup site and you can then, find out all the information you need. Okay, well, we're going to finish with a video which is about 5 to 6 minutes, but it's a sketch of the cabinet meeting and a takeoff of the cabinet meeting where the Prime Minister is defending the idea of British human rights and the European rights is not needed, and it's quite fun to watch. So we're gonna watch this, and when it finishes, the webinar is over. We won't be coming back. So this is the end of the webinar, and I should give you a warning. It does end with a sort of 4-letter words, so be prepared for shock. And if you're rather gentle, just put your fingers to your ears. It's quite fun to watch. So let's play the video to finish this webinar. Let me thank Audrey again for taking part. I mean, you really did a good job in the circumstances of having the code. And that was great. So thank you for doing that. Thank you everyone for joining us and for the questions you've asked. Anyhow, good night for now, and let's play out with the video and watch it. It is quite fun to watch.
Good morning. Before we start, I want to be absolutely clear about one thing. We are here to serve the British people, not the whims of some European imperialist state. We are a proud nation, and no bureaucrat in Brussels can tell us what to do. We are a democracy, not some perverse, genuflecting mouse puppet on a European finger. The idea of that makes me physically sick. They took our sovereignty, our dignity, the very essence of our Britishness. And what has the European Convention of Human Rights ever done for us in return?
Oh, the right to a fair trial.
What?
The right to a fair trial.
Well, that's true, I suppose.
The right to privacy?
Well, yes, all right. I grant you, fair trials and privacy are two things the European Convention of Human Rights has given us. But...
What about freedom from torture and degrading treatment?
Freedom of religion?
Freedom of expression?
Freedom from discrimination.
Oh, how about freedom from slavery?
Yes, of course. Freedom from slavery goes without saying. But...
Protecting victims of domestic violence.
Okay. But apart from the right to a fair trial, the right to privacy, freedom of religion, freedom of expression, freedom from discrimination, freedom from slavery, and freedom from torture.
And degrading treatment.
And degrading treatment, and protecting victims of domestic violence. But apart from these, what has the European Convention on Human Rights ever done for us?
Peace in Northern Ireland?
What?
Well, I mean, and the Good Friday Agreement depends on the European Convention of Human Rights. So without it, we'd have to make peace all over again. And what a palaver that would be. No, thank you.
No, look here. I'm not against human rights, of course not. But I say we don't need lectures from the frogs and the crowds.
Quite right.
This is Britain, the land of Magna Carta. We invented human rights, for God's sake. We should be writing our own Bill of Rights and foisting it on the Europeans. Let's see how they'd like it then.
We've already done that, actually.
What?
Well, after we won the war, British legal experts did draft a Bill of Human Rights to help Europe sort itself out, you know, protect people from abuses of state power, that kind of thing.
Really?
Oh, yeah.
You sure?
Oh, yes.
Oh. Well, that's good. What's it called?
The European Convention on Human Rights.
Oh, fuck off!